Lord Stevens will hand down the judgment.
This appeal concerns a challenge to the lawfulness of certain provisions of the Northern Ireland Troubles Legacy and Reconciliation Act 2023, the 2023 Act. The challenge is brought by Martina Dillon, John McEvoy, Brigid Hughes, and Lynda McManus, the applicants, each of whom has suffered because of crimes committed during the Troubles. The applicants argue that various provisions of the 2023 Act undermine rights previously guaranteed by EU law and now protected by Article 2.1 of the Windsor Framework, which forms part of the EU-UK withdrawal agreement. They also claim that certain provisions of the 2023 Act are incompatible with the European Convention on Human Rights, the Convention, as given effect in UK domestic law by the Human Rights Act 1998. The 2023 Act is a further attempt to respond to the legacy of the Troubles, the period of conflict in Northern Ireland that began in the late 1960s and continued until the Belfast or Good Friday Agreement of 10th April 1998. More than 3,500 people were killed during the Troubles, with approximately 40,000 injured. Around 1,200 killings remain unsolved. The 2023 Act establishes an independent commission for reconciliation and information recovery, the Commission, whose functions include carrying out reviews of deaths and serious injuries caused by conduct forming part of the Troubles. The Commission is given wide investigative powers. State bodies such as the police, the army, and the security services are obliged to make full disclosure of information, documents, and other material to the Commission without reservation and are obliged to assist the Commission with the information they have provided. In broad terms, the scheme of the 2023 Act was to move away from adversarial inquests, which were beset with lengthy delays, and to move away from investigations by the police and the police ombudsman. The move was to inquisitorial investigations capable of being carried out by the new independent commission. The 2023 Act brought existing police investigations, inquests, and Troubles-related civil claims commenced on or after a certain date to an end. The Act also introduced a conditional immunity scheme. Those who cooperate with the Commission by providing full information to it receive immunity from prosecution for the most serious of crimes committed during the Troubles. The applicants challenged several provisions of the 2023 Act. First, the applicants challenged the provisions which established the conditional immunity scheme. The applicants argue that the immunity provisions are incompatible with the procedural obligation under Article 2 of the Convention, which protects the right to life, and under Article 3 of the Convention, which prohibits torture and inhuman or degrading treatment. The applicants argue that under the Article 2/3 procedural obligation, those who have caused death or who have committed torture should be punished. Second, the applicants challenged the provisions in the 2023 Act in relation to Troubles-related civil claims. Section 8 stipulates the material obtained or produced by the Commission in the exercise of its functions is inadmissible in civil or coronial proceedings. Section 43, subsection 1, provides that Troubles-related civil claims commenced on or after 17th of May 2022 cannot be continued on or after 18th November 2023. Section 43, subsection 2, provides that Troubles-related civil claims cannot be commenced on or after 18th November 2023. The applicants argue that these provisions interfere with the rights protected by Article 6 of the Convention, which provides that in the determination of civil rights and obligations, everyone is entitled to a fair hearing by a tribunal. The applicants also argue that the prohibition on civil claims was unlawful, as the use of civil proceedings is one method by which a state performs its procedural obligation under Article 2 of the Convention to carry out an effective investigation into a death. Third, the applicants challenge the provisions which govern the conduct of investigations by the Commission. They argue that in Commission reviews, A, the absence of provision of legal aid for the next of kin, and B, the absence of provision for questioning of witnesses by the next of kin, mean that their rights under the Article 2/3 investigative obligation will be breached, as they will not be involved in an investigation to the extent necessary to safeguard their legitimate interests. The applicants argue that the Commission is not independent, and in particular that the provisions in the 2023 Act as to the disclosure of documents and information by the Commission to the next of kin mean that the Commission is not sufficiently independent from the state. Fourth, in relation to the immunity provisions and the provisions in relation to troubles-related civil proceedings, the applicants also argue that these provisions are incompatible with Article 2.1 of the Windsor Framework. Article 2.1 requires the UK to ensure that no diminution of rights, safeguards, or equality of opportunity, as set out in the part of the Belfast Agreement entitled Rights, Safeguards and Equality of Opportunity, otherwise known as the RSEO chapter, results from the UK's withdrawal from the EU. In response, the Secretary of State for Northern Ireland first sought to justify the immunity from prosecution provisions as being acceptable as part of a reconciliation process. Second, it was asserted that the Commission is independent. Third, it was asserted that the challenge to the provisions in the 2023 Act concerning the involvement of the next of kin in the Commission's investigations was an impermissible prospective challenge not based on the facts of an individual case. Rather, it was a challenge to the legislative scheme, and for such a prospective challenge to succeed, the applicants would have to establish that there will be no effective investigation in all or almost all cases, and fourth, asserted that there was no breach of the Windsor Framework. In the High Court, the judge determined some issues in favour of the applicants and others in favour of the Secretary of State. In favour of the applicants, the judge found that the applicants' EU law rights under Articles 11 and 16 of the EU Victims Directive had been diminished by the immunity provisions, and that their rights under the Charter of Fundamental Rights of the EU, the Charter, had been diminished by sections 8 and 43, subsection 1, in relation to troubles-related civil proceedings. The provisions were therefore disapplied by the judge under the European Union Withdrawal Act 2018 because the Windsor Framework had primacy over them. The judge also declared the immunity provisions to be incompatible with Articles 2 and 3 of the Convention, which respectively protect the right to life and prohibit torture and inhuman or degrading treatment. In addition, Section 8 and 43(1) in relation to troubles-related civil proceedings were declared to be incompatible with Article 6 of the Convention. In favour of the Secretary of State, the judge rejected the applicant's argument that the Commission was not independent, and given that he was not faced with a concrete example, declined to make any order in relation to the lack of legal aid for the next of kin or in relation to the disclosure of documents or information to the next of kin. The Court of Appeal upheld the trial judge's declarations that the immunity provisions breached Article 2.1 of the Windsor Framework and Articles 2 and 3 of the Convention. The Court of Appeal also upheld the trial judge's declarations of incompatibility with the Convention in relation to Sections 8 and 43(1). The Court of Appeal went further by making a declaration that Section 43, subsection 2, was incompatible with the Convention. However, the Court of Appeal reversed the disapplication of Sections 8 and Section 43, subsection 1, under Article 2.1 of the Windsor Framework, because these sections did not diminish the applicant's rights under EU law. The Court of Appeal held that the judge had been wrong to equate any breach of the Convention with a corresponding breach of the Charter. The Charter does not provide freestanding justiciable rights. It is rather an aid to the interpretation of relevant provisions of EU law. Finally, the Court of Appeal held that the Commission is not presently capable of carrying out an investigation in a way that is compliant with the Article 2/3 investigative obligation because A, the deceased next of kin will not be involved in the investigation to the extent needed to safeguard their legitimate interests, and B, the Commission is not sufficiently independent from the state in relation to the disclosure of documents and information by it to the next of kin, victims, and the public. The Secretary of State appeals to the Supreme Court on the question whether the Court of Appeal was correct to disapply the immunity provisions on the basis of a breach of Article 2.1 of the Windsor Framework, and we term that the Windsor Framework ground of appeal. The Secretary of State also appeals against the Court of Appeal's findings relating to the Commission's ability to carry out investigations compatibly with the Article 2.3 investigative obligation, and we term that the next of kin involvement and disclosure ground of appeal. The Secretary of State does not challenge the declarations that the immunity provisions in Sections 8 and 43 are incompatible with the Convention. This ground of appeal was abandoned before the Court of Appeal judgment was handed down after a new Secretary of State was appointed following the 2024 UK general election. The applicants cross-appeal against the Court of Appeal's decision to reverse the disapplication of Sections 8 and 43.1, arguing that their EU law rights under the Charter are diminished, and we term that the Charter ground of appeal. The Supreme Court has also been asked to consider arguments put forward by interveners in the appeal, including the Northern Ireland Veterans Movement. The Supreme Court, in a judgment which all the justices on the panel have contributed, unanimously allows the Secretary of State's appeal on both the Windsor Framework ground of appeal and the next of kin involvement and disclosure ground of appeal. It dismisses the applicant's cross-appeal on the Charter ground of appeal. I will now briefly summarise some of the reasons. The Windsor Framework ground of appeal. This ground raises three questions. The first question is whether Article 2.1 has direct effect. Article 2.1 has direct effect if, regard being had to its wording, purpose, and nature, it contains a clear and precise obligation that does not depend on further action by the EU or the UK before it can take effect. Article 2.1 of the Windsor Framework refers to the rights, safeguards, or equality of opportunity as set out in the RSEO chapter of the Belfast Agreement. It is therefore necessary to read the RSEO chapter and Article 2.1 of the Windsor Framework together to decide whether the test for direct effect is met. The Supreme Court holds that the paragraphs of the RSEO chapter on which the applicants rely cannot have direct effect because they are expressed in two general terms. Paragraph 1 refers to civil rights, mutual respect, and religious liberties. Paragraph 11 identifies the need to acknowledge and address the suffering of the victims of violence. Paragraph 12 refers to a right to remember. However, this does not mean that Article 2.1 of the Windsor Framework is incapable of having direct effect in any circumstances. First, Article 2.1 specifically refers to 6 EU directives, which all relate to the prohibition of discrimination. Article 2.1, taken with one of those EU directives, might have direct effect. None of those EU directives apply in this case. Secondly, Article 2.1, taken with another EU instrument that falls within the rights contained in the RSEO chapter, might satisfy the test for direct effect. In this respect, the applicants rely on the EU Victims Directive. The second question is whether the immunity provisions are in breach of Article 2.1. The Supreme Court's answer to this question is no. The EU Victims Directive guarantees the right to review a decision to prosecute, Article 11, and the right to a decision on compensation, Article 16. However, these rights do not fall within paragraphs 1 or 12 of the RSEO chapter. Articles 11 and 16 of the Victims Directive may fall within the subject matter of paragraph 11 of the RSEO chapter, but it is unnecessary for the Supreme Court to reach a concluded view on that further matter. This is because Articles 11 and 16 of the EU Victims Directive are concerned with the conduct of prosecutions in individual cases and do not regulate broader policy questions on when prosecutions should be pursued, such as a national policy on immunity for the purposes of post-conflict reconciliation. Therefore, the 2023 Act did not curtail rights conferred by the EU Victims Directive in a way which would have been impermissible had the UK remained in the EU. The third question arises if the answer to questions 1 and 2 is yes. If so, then the question is whether the Supreme Court was required to disapply the immunity provisions. However, this question does not arise, as the immunity provisions are not in breach of Article 2.1 of the Windsor Framework. The Charter ground of appeal. The Charter is a legal document that sets out the fundamental rights and freedoms and principles that are recognized and protected under EU law. Among the rights that the Charter protects are the right to life, Article 2, the right to prohibition of torture and inhuman or degrading treatment or punishment, Article 4, and the right to an effective remedy and to a fair trial, Article 47. The applicants argue that Sections 8 and 43.1 of the 2023 Act should be disapplied under Article 2.1 of the Windsor Framework because they breached the rights protected by Articles 2, 4, and 47 of the Charter. However, the Charter explicitly defines and limits its intended field of application. Article 51.1 states that the Charter only applies to EU members when they are implementing union law. The Supreme Court affirms the Court of Appeal's decision on the Charter ground of appeal and rejects the applicant's cross-appeal. The Charter was not intended to operate on a freestanding basis. This is supported by the text of the Windsor Framework itself and the implementing union law requirement in Article 51, paragraph 1 of the Charter. Beginning with the text of the Windsor Framework, Article 2.1 only applies to rights set out in the RSEO chapter, and the only arguable reference to Charter rights is the generalized reference to civil rights. However, this is not sufficiently apt to set out specific and enforceable legal rights, such as those contained in the Charter. Turning to Article 51.1 of the Charter, the settled case law of both the Court of Justice of the EU and the UK domestic courts show that, to be implementing union law, the Charter must be anchored in another provision of EU law, which the member state is implementing. As Article 2.1 of the Windsor Framework does not implement EU law, since the relevant paragraphs of the RSEO chapter did not set out directly effective EU rights nor Charter rights, the necessary anchor to a provision of EU law being implemented is absent. Accordingly, Article 51 of the Charter is not satisfied, and the Charter does not apply. The next of kin involvement and disclosure ground of appeal. The Supreme Court allows the Secretary of State's appeal on this ground because the applicants are unable to show that the Commission's investigations will breach the Article 2/3 investigative obligation in all or almost all cases. The applicants challenge the 2023 Act's compliance with the Article 2/3 investigative obligation in the abstract, rather than challenging a review carried out by the Commission in an individual case. For such a prospective challenge to succeed, the applicants must establish that the 2023 Act will give rise to a failure to comply with one or more elements of the Article 2/3 investigative obligation, so that there will be no effective investigation in all or almost all cases. This is a high hurdle which is not met in this case. In determining a prospective challenge, the Supreme Court is required to assess the scheme of the 2023 Act against the Article 2/3 investigative obligation. The outer bounds of that investigative obligation requires the state to conduct promptly some form of official investigation when an individual is killed by the use of force, or when there is a reasonable suspicion that a person has been subjected to torture or inhuman or degrading treatment. The Supreme Court rejects the applicant's arguments that the Article 2/3 investigative obligation is not met for the following reasons. First, the applicants contend that the 2023 Act does not provide for legal aid to be made available to the next of kin or victims for the purposes of representation during a review by the Commission of a troubles-related death or an allegation of torture. But it does not follow from this that there will be a breach of the Article 2/3 investigative obligation in all or almost all cases. The Strasbourg case law shows that whether and the extent to which legal aid for representation is required for investigations will depend on the facts and context of each particular case. Furthermore, it will rarely be possible to determine whether the next of kin or victims are sufficiently involved in Commission reviews and whether there has been an effective investigation until the investigation has been completed. Secondly, the applicants argue that without an ability to question witnesses in the inquisitorial system of the 2023 Act, they will not be involved in Commission reviews to the extent necessary to protect their legitimate interests. However, they cannot show that there will be a failure to comply with the element of next of kin or victim involvement in all or almost all cases, for reasons including that an inquisitorial system can satisfy the Article 2/3 investigative obligation. Thirdly, the applicants claim that the Secretary of State's powers to prohibit disclosure by the Commission mean that the Commission will lack independence in disclosing sensitive information to the next of kin, victims, and the public. However, the applicants, again, cannot meet the test of in all or almost all cases in relation to disclosure. Although the Secretary of State can decide whether the disclosure of information would risk prejudicing or would prejudice the national security interests of the UK, this power is not unrestrained, nor does the Secretary of State have the final say. The Secretary of State's powers do not mean that the Commission will lack independence in disclosing sensitive information to the next of kin, victims, and the public, nor that this will result in there being an ineffective investigation in all or almost all cases. The intervention by the veterans movement. The veterans movement is an unincorporated association of veterans groups who oppose the prosecution of those who served in the United Kingdom forces in Northern Ireland during the Troubles. In their intervention, the veterans argue that the trial judge and the Court of Appeal applied the wrong test when finding that the immunity provisions would breach Articles 2 and 3 of the Convention. They submit that there is, or it is possible that there is, a reconciliation exception to the general rule that breaches of Articles 2 and 3 must be punished, which applies where an amnesty or immunity is granted with a view to reconciliation following conflict. The Veterans Movement argues that the immunity provisions fall within this exception and so do not breach Articles 2 and 3. This ground of appeal was abandoned by the Secretary of State before the Court of Appeal's judgment was delivered. The Veterans Movement, as an intervener, cannot reactivate an appeal which the Secretary of State has abandoned. Therefore, the Supreme Court cannot overturn the Court of Appeal's decision on this point. The Supreme Court nonetheless considers it appropriate to express its view on whether the Strasbourg Court and domestic courts have previously recognized a reconciliation exception. The Supreme Court finds that the Strasbourg Court has not decided that there is a reconciliation exception, though it has not ruled out the possibility that such an exception may exist. The domestic courts should follow and keep pace with the decisions of the Strasbourg Court, no more and no less. In conclusion, the Secretary of State's grounds of appeal are allowed and the applicant's cross-appeal is dismissed.
Thank you. The court is now adjourned.